Bruce Solomon, ready to go?
Just about. May it please the court, I'd like to reserve 5 minutes for my rebuttal. This is a strangely difficult case, actually. This case begs the question, can the trial judge change his mind? And that's what happened. We have a ruling that is complete on its face. After 4 days of hearing, a full transcript was created. The trial judge...
We have rehearing motions so that trial judges can change their minds, right?
Not without a full transcript, without an opportunity to respond, that raises new points that are not supported by the record that existed before the trial court, and that re-argues old points that were already ruled upon in first motion, and that appeared ruled upon on the face of the actual first order. Because what happened here was the motion for rehearing raised new points that were not supported by the record. It repled and made old arguments that had been expressly accepted or rejected, depending on what the argument was by the trial judge at the first go-around, and included a passionate plea for justice because somehow the excuse was that the decisions that the former wife made were justified because she was oppressed and she had difficulty. But not days before, she had executed, with the advice of counsel, a full comprehensive parenting plan that employed the language of the form that we all start with, that's approved by the Supreme Court, uses language that's readily acceptable. They acknowledge at the hearing that there is no ambiguity. They acknowledge that there are 3 different points. I could go through all of the different machinations of the interpretations, but I think that what's most important for this court to consider is whether or not the procedure that was adopted or employed by the trial judge to reconsider without any apparent explanation. It wasn't like, oh, aha, there's something new. Everything that they raised, for example, they say this 24-hour notice provision in order to be able to explain this Sunday visitation. I didn't take that into consideration. Poppycock, it was a part of the record. It was a part of the motion. It was a part of the order.
Mr. Solomon, because trial judges, and having had the opportunity to serve, especially in family law cases, there's a lot coming at me. And I know the judge here made every effort when they first prepared the order, but that's why we have motions for rehearing. Sometimes things that are presented, perhaps the judge was laser focused on one issue, did not consider something else. And so the fact that the court properly exercised its discretion in re-evaluating in their mind that perhaps they were wrong the first time around, why not?
Well,
Give them
right.
that opportunity, especially if everything was on the record, everything was there, and sometimes when you present something to the court, you don't realize, oh, I didn't realize that this was possible there. So the beauty of motions for the hearing, it gives the opportunity to trial judges to correct themselves before coming up here and we reverse them.
That's a very practical solution. The only problem with that is that the only motions for rehearing that are actually recognized by the rules of procedure and authorized are for final judgments and not of these interim orders, which we have. Even if it was a motion for reconsideration that we kind of skirt the exact language of the rules to allow the trial judge to consider or reconsider a point, that's fine. But how did it become clear and plain at the first hearing?
This wasn't an authorized motion for rehearing. Are you here on an appealable order?
The order that was entered was the motion for, rehearing was granted and a new order was entered. So the new order was entered and it has to be challenged because that order was entered. So we're here on a proper jurisdiction because that.
Make sure I understood your argument.
Yes, ma'am, I'm saying, but what happened, the process that led to the execution, to the entry and rendition of the second order is flawed because there was no hearing, there was no notice. The order granting the rehearing itself acknowledges that there was no hearing on it. The motion for rehearing was
And that's
filed.
typical for motions for rehearing. The trial judge is required to conduct a live hearing on a motion for rehearing.
With with retreading old arguments and creating new arguments.
Did you
I
respond?
There was no response filed. I was not trial counsel at the time. The motion was filed on September 2nd, after hours on Friday night, and the judge ruled on September 23rd, entered both the order granting the rehearing, in which he summarized the rulings that he was going to be making in the amended order that denied the motions for contempt on all three grounds. And the points that Judge Kuzem was talking about, yes, sure, you want to be able to reconsider it, but you don't want to reconsider it unilaterally without the opportunity, because these were new points that were.
3 weeks went by before.
I'm sorry.
3 weeks before the trial judge disclosed of the motion for rehearing consideration.
Yes, it was the
But
20.
Your client didn't file a response during those 3 weeks.
No response was filed to that, because what the thought was that if the judge was going to grant the rehearing, then there would be an opportunity for a hearing and a response. That's what a rehearing was. It specifically asked for another audience with the court. It didn't say just vacate that order, Judge. That wasn't the rehearing. It was a motion for rehearing and reconsideration. Give us the opportunity to respond. When the motion for rehearing was filed, it was only filed with partial truncated pieces of the transcript.
Well, I read your brief as raising all these merits issues, and now I'm not quite sure what your position is. Were you denied due process?
I think we were denied due process. I think
You don't make
that.
that argument in your brief, do you?
But we don't make the argument in the brief but what happened was the issue, we challenged the rulings because they could not possibly have been made without a response, because they were retreading of things that the judge had already ruled upon. For example, he had said the language was clear and plain, and now all of a
That's the
sudden.
issue that the trial judge can revisit on rehearing. And that's exactly what he did on the other piece, isn't it?
And your client had 3 weeks to submit something. Say, hey, whoa, what's going on here?
With the expectation, right or wrong, because there isn't any rule that says how that's supposed to happen, it's not a matter of, it was grant the rehearing, give me an opportunity to come forward and either brief the situation.
Because that's really not the case. Motion for rehearing get filed all the time, motion for reconsideration hearing. The trial judge, if I'm a trial judge, I have to give you a hearing on your motion for rehearing. I have everything before me and probably realize, oh dear God, I must have missed this issue. Let me fix this. This is well within the prerogatives. I just want to correct you. I don't believe there's any law or any rule that requires on a motion for that the court to grant you or to grant the parties a hearing on a motion for hearing. The court could do that on its own. And if something's out there that says to the contrary, I'd be happy to hear it.
So I'm not familiar with anything to the contrary that mandates that you get an opportunity, but when the motion for rehearing directly retreads things that the judge had already ruled upon and raises new matters by employing a truncated transcript or a portion of the record without a response, and the judge doesn't ask for a response before the judge rules on that, when the light was red first off and now it's green, and the language was specific in the first order, by the plain terms of the parenting plan, the father was entitled to Sunday time sharing. There was not any sufficient reason given by the mother not to allow it. Clearly, the father had the opportunity. That's the first order, and that's based upon the record, supplemental record 189 to 90, we cite where the mother acknowledged, and the mother's counsel acknowledged, that based upon paragraph 4 of the parenting plan, father was entitled to the time sharing on that Sunday. They make all sorts of extraneous arguments about how maybe it wasn't a good idea, maybe it should have been communicated differently, otherwise, but she was clear, and she said, no, I'm not giving it to you. And the reason that they give across the board in their motion was because the former husband made incessant demands. He was demeaning, condescending, and threatening. Well, that's the theme already also of the brief, because the brief is, they're harassing me. Therefore, I should have free rein to do what I think I need to do to protect against the safety, for the safety concerns. What are the safety concerns, ma'am? that doesn't have any idea what that is. I'm concerned about the safety concerns. So that justifies the conduct of that. So we texted it and went through this process. And with respect, just to be, the Sunday time sharing may not be the best example of,
And that's not where you respond.
Of the pro-
Sunday, you would have believed, and on the point of the video, you realize, ooh, it's going to be 24-hour notice, and there was not.
well, but how could there be 24 notice?
If, the language says that you give them notice, and he contacted her that day, said, I'm coming back, I'm gonna exercise my right. And I go back to the court has every right, Mr. Solomon, to reconsider their position based on what's before that. And maybe in the motion for rehearing, things were brought in a different light. It's the same context, but it's a different light, and it's well within the court's prerogative. The court is not required to ask your client for a response. And I go back to what Judge Rose said, I was telling you, for 3 weeks, there's no response filed. Mind you, you were the attorney of record, but there's nothing that was.
We get
filed.
criticized for filing too many things.
At least with that, Mr. Solomon, we have to look at it all in context. You're up here on the non-final order for us to review. Was it an abuse of discretion for the court to do what it did? And granted, you've got good arguments, but we have to look at the context of this case. Can we absolutely say that the trial court was dead wrong in doing this?
Well, let's just take that one issue. I acknowledge that the Sunday time sharing may not be the hill to die on, but nonetheless, that 24-hour notice period begs the question. That's if you want to change the schedule. The presumption is that they're going to have for this 1 year period that the word is can, like in the prior case, it could have been a better word, but can have that. And if somebody doesn't want to have that, then they have the affirmative obligation to give that notice, either parent. If you can't make it, and because it doesn't say only the parent that is going to take advantage of that.
We've kind of beaten the Sunday timeshare pretty hard already. What about what the trial judge found on reconsideration that the wife buying a car, and allowing the child to use it is not contemptible because it just was not sufficiently documented or prohibited, or the parenting plan wasn't sufficiently specific to lend itself to an interpretation that the furnishing of the automobile was a contentious act. Talk to us about that a little bit.
A major decision for a 16-year-old to be able to do that.
About buying him a car.
But there are,
Get a car.
but when you give privileges to children, they don't necessarily just come carte blanche, that the mechanism by which they have to use it, what kind of car it is, when they have access to it.
Solomon, the parents talked about this. They were in agreement that they were going to give the kid a BMW. And then your client basically took the position, I ain't paying for this. And then what more can the wife do?
Well, he didn't say that he wasn't going to pay for it. He said he went back and forth and there was some grizzle between them as a result of that. But that doesn't allow her to just go out and say, I'm going to do that unilaterally. And the fact that she titles the car, she couldn't title the car in the name of the minor. So she goes, and then she did the same thing with the cell phone. She sends her brother to go get the cell phone. It's titled in his name, but it says that right on the form, and I can give you the citation, right on the form, that the user of the cell phone is the child, is the 16-year-old. It's
The phone suffers the same problem, which is the trial judge found in the end that the providing of a second phone in no way impeded the father's ability to communicate with the child.
Well, she created a situation that was the result of. It's like when you
That was not the result. There's no evidence that the child discarded the other phone.
Oh.
There's no evidence that that the father was not able to contact him. He may not have been able to follow him, but there's no evidence that there was no,
She didn't
failure to contact.
Yes, he went. The testimony about not being able to track, you weren't able to speak to him either because he didn't have the phone with him. That's why there was no communication. If the tracking and the verbal communication by the telephone are the same, effectively the same thing. She says, you don't have to take this other phone, just take the one I'm going to give you.
With the time sharing, the parenting plan specifies that there will be contact information that will be kept up to date.
Hers and
his, and
right,
I,
okay, the
I,
part,
I have a problem seeing that that's a contemptuous act.
getting him a phone and saying, leave the one that your father, that we otherwise agreed is going to be the phone you're going to use, because that was an agreement. He has this phone, mom and dad agree. You don't have to use that phone.
Who testified that the minor was told to leave the phone home? Whose testimony was that?
I hesitate to say, I'm not 100% sure
So
whose
we don't have the
testimony.
minor testifying directly.
Oh, no, the minor didn't testify.
And we don't have the mom testifying directly.
That's what the judge found. I didn't go back and recheck that transcript, but the judge found that she did not require him to keep the phone. And it's
Excuse me, just to remind you, you're into your rebuttal time, but use your time as you wish.
They say she didn't prohibit him from doing it, but she encouraged him not to take the second phone. Only using one. I don't know what the result is. The analogy I was going to draw, it's like we learn in torts 1, there are 2 types of intent. There's when you push somebody down, that's one intent to make them go down, but the other is when you pull the chair out from under them and you know that they're going to fall down because they're trying to sit on the chair that you've just pulled out. This situation is one where she says, don't take the phone, here's another one. I don't want you to be carrying that phone. The judge so found that finding wasn't changed as a result. I appreciate it. I want to save some time for rebuttal,
Okay.
but thank you.
We'll give you 4 minutes, Mr. Solomon. Mr. Vesely? Oh, I'm sorry.
Good morning, Your Honors. Shannon Troutman on behalf of the appellate. I'm here with my co-counsel Brendan Vesely and my client Lily Andreopoulos. As has previously been discussed, there's no basis to overturn the trial court's ruling. First of all, the process of the rehearing wasn't raised as an issue in the initial brief, so it should not be considered now. In addition, Florida law has consistently held that there's no requirement that a trial court hold a party in contempt, even if there's a factual basis to do so. We're not contending that there is a factual basis to do so. But even if this court were to find any of the acts contemptible, the trial court wasn't required to hold the wife in contempt.
Can you go back? This is a sea change in the court's order. Do you have any hesitation that the court probably should have held a hearing in person, or what of the response? Because it's like, it is a sea change, you'd agree?
I would agree, but there's no requirement that the court hold a hearing or require a response. As Your Honors stated, 3 weeks passed between the motion for rehearing, reconsideration, and the order coming out. I think what you'll see that could have led to the sea change is it was a 4-day hearing over multiple months. The court didn't have all, it's easy to misremember things or not have everything in full context when the process takes that long. And so what the court did, as Your Honors stated, is realize, oh, maybe I got this wrong. And with more fact, the whole record in front of it, got it right the second time. Would you like me to go into detail on any of the potentially contemptible
Your
issues?
time, use it as you wish.
Okay, I'll just hit the highlights then. First of all, again, a finding of contempt is an abuse of discretion, and there have been no cases in the past 20 years in Florida overturning a decision not to hold a party in contempt. You've already discussed the Sunday visits. The order, the parenting plan is ambiguous as to the Sunday time sharing. It could be considered an option, a requirement, or a schedule change, all of which require a different method of notice or enforcement. And that when something can be interpreted more than one way, it's clearly ambiguous. And when an order is ambiguous, you can't find a party in willful contempt of it. As far as the car, as your honors touched on, they had been discussing the car. The wife testified that she thought it was her responsibility to pay for the car. She bought the same type of car that they've been discussing and that both parents drive. And with regard to the car, the later concern coming up about.
You agree it's a major decision?
It's not defined as a major decision in the parenting plan.
The parenting plan gives examples of what is a major decision. It's not an exclusive list.
It's not, but it touches on healthcare and education, and makes
Well,
decisions.
16-year-old boys driving cars, was a sort of de facto healthcare concern. Would you agree? I mean, every young male has adult children, we've all been through it.
I don't, so maybe that's where I come from. But I would also say that the parents provided the son with a motorboat before, so I'm not, and it was specifically given to the son as part of the marital settlement agreement. So I find it hard to distinguish between a motorboat and a car.
But the trial court did find it was a major decision.
It did originally, it then changed its position.
Well, if you're in a situation where the parents agree the kid needs a car, they're in agreement as to what kind of car it's going to be, but they reach an impasse on how we're going to pay for this or finance it. Isn't the proper remedy to go back to the trial court and say, trial court, what does this MSA mean?
I don't, again, because the order is ambiguous and the mother did not believe that it was a major decision based on the fact that they had all these discussions already. She paid for it completely herself. There are multiple emails where the husband stated, go ahead and buy a car. I don't think it was necessary for her to go back to the trial court to have it decided. And then finally, I wanted to touch on the second cell phone. There is absolutely no evidence on the record that he didn't have both phones on him at all times. There's plenty of testimony that tracking was turned off, but that doesn't mean you don't have the cell phone.
Well,
And
the provision that talks about communication also says that telephone or other electronic communication between children and other parent,
correct.
who are not having time sharing, shall not be monitored by or interrupted by. Can you
Exactly.
address that?
Yes, I would argue that that was exactly the wife's concern when she purchased the second phone. She would get, for example, there was an issue with the oldest son's curfew while he was under the wife's time sharing. And she then received messages from the father because he had been tracking the son and knew what time he got home. And that interferes with her ability to parent the son while he's under her time sharing. And the fact that the second phone was discovered while the oldest son was in bed and he had both phones on him, I think that shows that he wasn't leaving one behind. And there's absolutely no evidence showing that the wife told him to ever leave the father's phone behind. There's just nothing on the record about that. Any other questions? Okay. Well, we would ask you to affirm the trial court's ruling and to consider. Yeah. And to consider our motion for attorney's fees. The parent or the MSA allows for prevailing party fees, and we would ask that you award our appellate attorney's fees. Thank you.
Thank you. I feel a little bit under the gun, but I'm going to try. With respect to the second cell phone, there was no monitoring of mother's communications with the minor child. The trial judge found that she had surreptitiously provided the second cell phone, that she instructed the minor child not to tell the father about the second cell phone, and that she allowed the minor child to carry only the second cell phone. And the parenting plan, as I thought Judge Britt was going to go to, includes all means of communication to supplement the face-to-face. And he was concerned that there's plenty of testimony about the problems that this 16-year-old was having in school and with curfews and other things. And it's hard to criticize a father who cares. We see so many fathers and parents generally, I suppose, it's not limited to gender, that don't care enough. And he now says, what's this child who's getting D's doing at 1:30? The first order providing the cell phone says that providing the cell phone itself is not contemptible, but instructing him not to tell the father and allowing him not to carry it. And then all of a sudden, we don't know what has changed, what the thought process was of the trial judge, that what changed, that now all of a sudden there's insufficient evidence that the interruption was willful. What was it if it wasn't willful? It was clearly interruption, and now it's just the question of whether it's willful or not. There doesn't seem to be any issue with respect to the ambiguity there, but when we get to the car issue, the trial judge, when we got to the fees hearing, there was a fees hearing of the trial court proceedings, and the trial judge was troubled that there was no authority for what was a major decision. I'm going to take the whatever I can take from this hearing and advise Judge Ellis, if it gets to that point back, that's the issue, that this is a major decision, besides the fact that it was stipulated both by the mom and by her counsel that it was a major decision, as the panel knows, and I have kids that also meet that criteria. He says that there's no clear definition, but it doesn't really matter. We all agree what it is, and they agree what it was, and we threw in about the Supreme Court form being the form. Ultimately, I don't understand how it was plain and clear even on the Sunday time sharing, and she agreed, it started on Friday. This new constructed, the plan didn't start until Monday. Well, that's because we break up the week and we create the graph, and you've seen the chart of how Monday, Tuesday is mom and dad, and otherwise, that doesn't mean it started then. It said it was effective when it started on the 15th. That was what it was. There's so much that was going on. And here you heard at the end of this, my final concluding remark is it's all about the attorney's fees now, because now they spend a C note, they spend over $100,000 in the case. Now go to Judge Ellis and say, I want those fees. Now they want appellate fees to do what happened when it switched. Well, sure, we want, but that's what this has turned into, the tail that's wagging the dog on the issue, because what happens now, it's a year later. This all took place September of 22. So now we've got this issue of what's going to happen with all of these issues. I mean, that nobody's going to remember these things in practicality terms of parenting. There's so many things that happen every day with a 16-year-old and their two other younger children. Thank you very much. I appreciate the audience.
Thank you, Mr. Solomon. Thank you both. Next case is Jimenez versus Jimenez.